Our next speaker is a professor of law in the University of Canberra and an internationally recognized leader in the fields of corporate social responsibility, corporate law, and regulatory theory. Professor Benedict is a highly cited law academic, a fellow of the Australian Academy of Law, and formerly practiced as a barrister and solicitor of the Law Society of Upper Canada. Professor Benedict is an interdisciplinary researcher, having published in the disciplines of law, business, economics, psychology, and philosophy. So without further ado, let us welcome Dr. Benedict Sheehy.
Good morning. My mom fed me a lot of food. That's why I got tall. Thank you very much for the opportunity to speak to such a distinguished group. It's a pleasure. I like to acknowledge particularly former Dean Fides Cordero Tan. We've become great colleagues, good friends over this. You don't like me, it's her fault. She dragged me in years ago, so thank you particularly. So we can have presentation. And what a question, right? What to teach when teaching law? You're all law professors, law deans, very advanced. But I thought about this and I've been listening to the discussion, and this is sort of the little secret. We've got the beautiful law school, the lovely technology, the handsome and beautiful law lecturers, and we crank out these law students. But what's inside the sausage factory? And so what I wanted to do is talk about this. I'm not like you people, very organized with nice notes. I'll just talk. What I wanted to do is talk to you, what do we do about teaching? And there's, I came to law lecturing when I was about 40 years old. And I've just seen from my own experience, thrashing through and other law lectures when I was a law dean, seeing how people struggled to teach law. Okay. And, you know, what we're going to look at today is, why is this a question, what to teach when teaching law? Why do we ask that question even? And one approach to doing that, which I'll introduce today: categories, rights, duties, and tests. Can everybody just say that with me one time, those four? Categories, rights, duties, and tests. Good. Watch that. Okay, next slide. So what are the three approaches that lawyers or law professors have? There's far too much on there to read. You're all advanced readers. You don't need me to read it to you. Three things we do. Death by detail. That's what this slide looks like, right? The problem is the students get completely lost, overwhelmed, discouraged. The next model of law teaching we have is the professor on a soapbox. I really care about this, and this is the one issue in my life, and I'm going to teach about this. Problem is the students don't understand the whole area of law. They understand your little soapbox, good for you, or good for me. The other thing we do is called neighbors and fire hose. When we're, right, oh, what's the law on this? I don't know what to do. I don't know how to figure it out. I'll go ask my neighbor. There was a judgment in Canada when I was still in law school in the 1990s. And the judge made the comment, it was a Supreme Court of Canada case, and the judge made the comment that when he was going to law school, the problem was to find a case. That the problem today is you've got a fire hose of information. How do you control it? And so if you look at these different problems, it really tells us that we've got to start thinking differently. I really liked Justin Mann-Harris's comment yesterday, that it's the peopleware that's going to stay the same. And so what I want to talk about, if I can borrow his terminology, is kind of the peopleware bit. What does a law professor bring to law students in teaching? So let's go to our question. Next slide, please. Answer the question with a question. What to teach when teaching law? Well, you ask the question in the first place, what do you want the student to take away? What do you want your student to take away? And this is something that tech panel was talking about. And what we tend to do then is we sort of think, oh, they need to take away 30 cases. This was Schwade's comment, right? 30 cases. I don't know about you. I can't remember all 30 cases that I've even assigned. Why do you expect them to get it? Or you want them to know the rule in Shelley's case of 1581. Is that going to really be helpful? Is it substance that we want, or do we want to teach them a way to think, a method for dealing with legal problems? Remember, we've got this fire hose problem. Okay? So we need to teach method. And that's why I want to teach categories, rights, duties, and tests. In addition, and I think this is a critical point, and I find this very interesting, what you're doing here with LEAP is recognizing law as a political program as well as a profession. So it's got those three elements: the positive law, a political program, and a professional practice. Okay, next slide. There we are. But this goes back to the basic professor's problem. How many of you remember this? What is law? And how annoying it is when the professor says, what is law? But it's an important thing because, we all say, we know what law is. Law is a command backed up by an authority, right? And that's what the black letter we teach and what the bar examines, correct? You know what? That's a lie. None of you guys believe that. We don't believe that for a minute. There's no law without you, without a law dean, without a law commissioner, without a law professor, without a law school. Without these institutions, law doesn't exist. So we're actually all legal realists. We're not just positive black letter lawyers. We don't believe that. So we need to be teaching our students what we actually believe. Next slide, please. So what do we teach? This is why I think we should teach this. Everybody, categories, rights, duties, tests. All right. And the three aspects to law: the positive, the political, and the professional. So let's go through this and see what it actually looks like. Next slide, please. I have to be honest here. Professor Attorney Tanya warned me, Ben, you're before lunch. And I've learned one thing in the Philippines: do not get between a Filipino and their food. All right. So as you think about what law does, law creates is really just dealing with human behavior, doesn't it? And you think, it's behavior between two people, a contract. What's the difference? I say to my students, what's the difference between a contract and an agreement? I shake hands, or I say, I love you. And then I turn around and I do something evil. Have I broken is that a contract? No. So what we're doing is we're creating categories in human behavior. This is a category of human behavior, an agreement that's not recognized by law. Here's a category of behavior, agreement that is recognized by law. What's that category called? It's called contract. Start creating categories around human behavior and then subcategories. So you start teaching law not as a random list of rules or arbitrary rules that are just plunked on each other, but categories. And this is something you all deal with second languages. When you study another language, here's the rule: subject, verb, object. Oh, good, I got that. Now, unless you're using an adverb, which can be used to modify the verb, or it also can be used adjectively. Well, what just happened? Your understanding of the rule is gone. You get lost in the details. Don't get lost in the details. Start with the categories. Teach the students to locate behavior in the legal system. Okay? If I take something from you, what category does that belong to? It may belong to theft, or it may simply be a temporary transfer of property rights gratuitously. That would be gift. Or it could be done on a leasing basis. So we look at our bundle of property rights. Look at human behavior. What category of law does it fit into, and start refining the categories. And that's what you do. You ask your students, what category that can I put this behavior into? Which category of law is suited to that behavior? There's no law on an island when you're alone on an island, right? It's human interaction. It's human interaction. Next slide, please. So this is what you do. So this is an example of tort. You make it visual. We were talking about different styles of learning. Make it visual for the students. I draw boxes. Here's tort. On the box on the left is intentional tort. On the box on the right, unintentional torts. These boxes represent categories. Inside unintentional torts, there's two subcategories, nuisance and negligence. Those are different categories, right? You start thinking, this is how we're categorizing behavior that maps against law. Next slide, please. And then what you do, once you're in a category, then you start saying, what are the rights and duties in that category? That's why categories, rights, and duties matter. You only have rights if you can fit in a category. If you go to a court and you're not in a category, the most the judge can say is, gee, that's too bad. Right? You need rights and duties. You only have rights and duties when you're in the category. And to make sure that you teach those rights and duties together. Here's a basic one that I love with property law when I teach property. Say, what's property? And, oh, it's land, it's a house. No, it's not. It's legal, so it's ephemeral. It's ethereal. There's nothing, no physical phenomena. And the basic duty of property is don't touch my stuff. It's an exclusionary right, right? That's the duty everyone has. I have the right, don't touch my stuff. You have a duty, don't touch it. Rights and duties go together. When you look at how property law remedies are crafted, they're crafted in order to remedy the breach of that exclusionary right. Okay, so rights and duties, they are extracted from the categories, dealing with human behavior. Next slide, please. So then it becomes this question of tests. So what's law about? Categories, rights, duties, tests. Why are the tests so important? The test gets you into the category. And explaining it to the students like this, for a judge to give your client $100,000, you must demonstrate that your client passes each element of the test to get into the category. That's why the category is important. That's why the test is important. If you don't explain that to them, oh my goodness, the doctrine of consideration. Consideration flows from the promisor to the promisee, or was it from the promisee to the promise? Okay? If you can explain, here's how that works. This test is important because your client's getting zero other than the lawyer's bill if they don't pass this test. Oh, and your cut on the bill is 30%. They're very interested. So if you're teaching law that way, rather than the 17 cases on consideration, they'll pick up the parts that they're struggling with, they'll figure it out, and they're motivated to figure out the cases that matter, the 17 cases, they'll figure it out. You explain to them how to do it. I really like Commissioner T, I just call her JoJo. Thank you. Comment, we're dealing with adult learners. And so they're motivated, and it's really just giving them a ladder to climb up to figure out. Give them the framework. Next slide, please. So what does this look like when we do it in the classroom? So this is something from an area of law you'll never have to deal with. This is the Civil Law Wrongs Act from the Australian Capital Territory. Section 43, precautions against risk, general principles. And you can see here, a person is not negligent. So that's the positive law. I'm not going to go through it all. But you see straight away we're in the category. What's the category? Tort of negligence. All right. What's the test? It's a cumulative test. 43, it goes 42, 1A and 2 and 43, 1. That's your test to get into the category. What's the right? Your right is not to be held liable for a breach of duty. In certain instances, okay, a corollary right is to hold someone liable where the duty has been breached. Okay? You have a duty then to take those precautions. So you can see how this category rights, duties, and tests works. Okay, I teach tort law and I teach corporations law. I use this method, the students get it. And you know what I make them say? Categories, rights, duties, and tests. Next slide, please. So then we also need to think of law as policy, because it's not enough to navigate the positive law. Categories, rights, duties, and tests helps them navigate that. And what you do then to teach the policy is you say, why was the category created? Who benefits from that category? Who bears the burden of that category? Which part of society advocated for it and which part opposed it? Next slide, please. So you can look at this with respect to tort when we're looking at the creation of rights and duties with respect to the category of negligence. Why was the category created? What it does, it allocates risk, encourages care, and ensures there's compensation. Okay? Start thinking about law this way rather than this provision, that provision, this provision, that case. Who does it benefit? It actually benefits the general public. Who's bearing the burden? The careless parties. And you can think of it, which part of society advocates for it or opposes it? People who are interested in social justice are always looking for tort reform, expanding tort. People opposing it are the insurers, unless they've got a smart marketing plan. Next slide. And so then we can also think about law as the profession. And the professional aspect of it, really the policy is the macro level, the professional is the micro level. And as professionals, we're taught to solve individual client problems. And so professionally, I think this is very, very important, is to ask, what is this going to look like when a client walks through your office door? What is that client going to look like? What's the fact pattern going to be? And you can give some examples from practice, or this is where local newspapers, always fun and interesting, where, I will say the news are poorly written short stories about people's bad luck and general human stupidity. But there's always something in there for tort, for corporations, for commercial, whatever it is, right? There's always something in there. And that helps the students to grab a hold of something concrete, a story they can relate to. The rule of, 1581 rule in Shelley's case, ooh. But when somebody dies intestate today, and there's a newspaper story about it, now I get it. Okay, next slide, please. So we're back to tort. We think it's important to remember negligence is not a closed category. That's what the judges tell us. And we ask, what does this behavior look like? What's the fact pattern look like? And you can think of it, careless driving, injury at the mall, product liability like our poor friend Wile E. Coyote. All right, so to think about what it is we're trying to teach. Next slide, please. So that this question, should we teach substantive content or should we be teaching method? The reality is it's a false dichotomy. It's a false dichotomy. And what you're doing is you're creating this framework, categories, rights, duties, and tests. That framework allows them to hang that substantive content. It sorts that substantive content out for them, and it makes it very easy for them to deal with that fire hose information. All of those statutes, all of those cases, categories, rights, duties, and tests, and it helps them organize their thinking. Even they'll do drawings of this. What I do here, and I do this even online, I always used to do it face-to-face, but I did it online. And you can see the third dot point. Make it easy for students, repeat it as a group, even online. Categories, rights, duties, and tests. Everybody together? Categories, rights, duties, and tests. Now, slide's gone away. I said it's very annoying when people treat you like a child and you have to repeat all together, boys and girls. But it works, right? And that's really our objective, is to help get things into our heads. They'll be annoyed, amused, or enthused, but they'll have a takeaway, right? They'll have a takeaway. And you may be surprised to see them years later. And I've had students come to me years later and see me on the street at that point. I always tell my students at the end of class, please, if you see me on the street, say hello and say something nice or nothing at all. But they'll come to me and they'll say, you know what, Prof, that really helped me. Categories, rights, duties, and tests. I got into the law firm and they asked me a question and I could put this straight on the table for them. And they said, good. And it really helps them sort through, become better professionals. And that's really what our goal is, right? Better professionals can manage the law. You put on that, the policy and professional layers, and you've got competent law students coming up. So that's all I'd like to say.